This week on Lewis on the Law, I've got another great show for you. I have attorney Ken Crosson on with me, and we're going to talk personal injury by looking at a couple of cases.
Welcome to Lewis on the Law.
You are listening to Lewis on the Law. My name is James Lewis, and I have yet another fantastic show for you guys. I have attorney Ken Crosson on with me, and we're gonna talk about personal injury, but we're gonna do it by taking an in-depth look at a couple of cases. Ken is the managing partner at Piedmont Injury Law, and you have a great background in personal injury, don't you?
Well, you know, I've been practicing. We're coming up on our 10th anniversary.
Uh-huh. And, that's a great anniversary. Is someone going to get you a present, like one of those iron chairs, or what is the 10th year anniversary? Me and my wife are approaching that, so I better start to sharpen up on it.
Is the 10th the Iron Throne anniversary?
Yeah, the Iron Throne. Just make sure there's no swords sticking out.
I don't need that. No, no. We're actually my firm. I love what we're doing. We're doing all personal injury work. We've got a strong focus on kind of giving back to the community. And we've decided that our 10th anniversary, we're calling it our 10X anniversary, because that's when we're going to 10X the impact that we're having on the community. We've got some new initiatives coming out. We'll probably not talk about them today, but a lot of things we're going to be working on in the coming year to really make a difference up in Cobb County.
Okay, so you guys do stuff in Cobb County. I guess you're located in Cobb County.
Well, we practice all over Georgia, and we take cases from all over Georgia. But yeah, geographically, we're in Cobb County, Marietta, and Northeast Cobb, and so naturally, a large percentage of our cases come from up there.
And you almost focus specifically on personal injuries.
That's all we do.
Okay, that's all you do, and that's the way to actually become an expert in something. Okay, so we're going to take a look at a couple of cases today. I thought I kind of get into this topic by breaking down the elements of a personal injury case and letting our listeners. I mean, this show is all about empowering our listeners. So a lot of what we do here is let people know if they have a case, what type of things they need to look for, and what type of issues may be available to them, and what type of attorney they might want to find to handle their case for them. So I think this first case we're looking at is Kerr Brothers versus Spahos, and these are Georgia cases. So we're looking at Georgia a little bit, and it's about an independent contractor who installs a furnace and he doesn't do it properly, and the house burns down.
Yes, it is. And what do you want to talk about this case? Because it's got all kinds of the little bits that you look for in discussing the same issues that you discuss in a personal injury case, but where do you want to start?
Okay, yeah. So when you're talking about a personal injury case, it's not just that a person got injured. I mean, I think this case did a really good job of breaking down the elements of a personal injury case.
Right, and that is, I guess that can be a little bit of a misconception. Sometimes people think, hey, I was in this place and I slipped and I fell, and therefore somebody owes me money, or something bad happened to me and therefore I'm entitled to recovery. And that's not really how it goes. You kind of start with the idea of what we call negligence, which everybody, of course, has heard the word and uses it. Maybe not in the strict legal sense, but when we're talking about negligence, we're talking about
negligence is a big legal word. It's a whole it's a whole legal topic.
It's pretty much 95% of what we deal with in our firm is cases involving negligence, which means that you've got a person who had a duty to act in a certain way or to refrain from acting in a certain way. Typically, that certain way is simply what the law would say is reasonable, what an ordinary person would find to be reasonable under the circumstances for that person in that context. And if the person fails to act reasonably, therefore acts negligently, and then causes injury to somebody to whom he had a duty to act reasonably, those are the elements of negligence, which then give rise to a claim for liability.
Yeah, I think this case is interesting because the courts broke it down into two types of, and they took a look at duty, that the vendor had a duty to the homeowners, and one duty was ordinary care, and the other was to not act or not to give something that's imminently dangerous to a vendee.
Right. Now we're talking about getting outside of. I mean, it's just another flavor, really, of negligence, right? But when you enter into a commercial contract, like you purchase something, there are express terms to that contract. I'm going to pay you this. I'm going to get this amount of whatever it is you're selling me. It's going to be delivered at this place and time, and the other things that you might express. The law implies additional promises, additional warranties that the vendor makes that that the item that's being sold is what they call merchantable. It's not going to foreseeably cause harm imminently to the person who it's being supplied to.
And I think we're going to get into the hot coffee topic in a couple of weeks, and our friend Jerry is going to bring that. But that brings to mind that who would have thunk a cup of hot coffee would have done that?
You all come. Make sure you listen to Jerry when he talks about the hot coffee case. I could talk about that case all day.
Yeah,
I'm a kind of envious that he's getting that topic on his.
Well,
his,
he was
appearance.
He was the first one. He was like, you know what? I want to go on and talk about the McDonald's hot coffee case. And we talked about it months ago. So
I'll give myself 30 seconds to talk about it. And it's a great case because I think it exemplifies so many of these issues, but it's also so widely misunderstood. And I think that's not an accident. I think it's widely misunderstood because it's been widely misrepresented by people who have a vested interest in people's misunderstanding that case. So Jerry, knock it out of the park.
Yeah, and even when I first heard about it, I'm like, she got how much for a hot coffee spill? That's not right. You could just sue anybody in America for anything.
Yes, but I won't spoil it because I know he's going to do a great job talking about this case. But yeah, it's not quite that simple.
It's not that simple, exactly. There's more to it than meets the eye, you might say. Okay, so back to our case. So in our case of Kerr Brothers versus Spejos, we have an independent contractor who installs a furnace, and he does not get an inspection. It is not to code, nothing, and the house burns down.
Right. Now this case is, I don't remember now exactly the year, but it's got some age on it, doesn't it?
Yeah, I think it does.
And so some of the ways that the court discusses the issues, it's not exactly how we look at things now. There's a concept that kind of skirts around right there around the edges of negligence. We call it negligence per se, and that kind of flavors this case.
Okay, so negligence per se. Break that down for me. What are you talking about here?
Right. So it is presumed to be negligent if you violate some kind of ordinance or statute or legal requirement that is put in place for the protection of a certain class of people, and as a result, you injure a person who is a member of that class. For example, in this case, the person installing the furnace had an obligation to follow certain inspection regimens. I don't believe the court uses the term negligence per se in this case.
No, I don't think they do. But it's a good thing to touch on.
Where the regulations have been put in place for the protection of, in this case, people homeowners who are having their furnaces installed, and the person installing the furnace didn't adhere to the requirements of the regulation, and as a result, injury to the person who is supposed to be protected by that regulation resulted. So that allows you don't even have to prove that it was objectively unreasonable to an ordinary person. You simply have to prove that it wasn't in conformance with the requirements of the law.
And this definitely wasn't built to code in the first place. He never had it inspected, and what do you know? The house burned down. Yeah, surprise, surprise.
When you have a bad outcome like that, you follow the chain back. There's usually something that explains it like that.
Yeah. Now, do you think this type of thing is common? I mean, people get a lot of work done on their houses, and I don't think I think I've had stuff done on my house, and I'm sure it isn't to code.
That is that's a great question. And let's not get too far afield into like just abstract things here. But I think with people for whom budget is a much tighter consideration, they're much more likely to get somebody who's going to cut corners, and those cutting of corners can end up being a big cost. I mean, it's like almost everything else. If you're able to pay for the premium or for the full service, you sometimes end up happier with the result, and sometimes it ends up being less expensive because your house doesn't burn down.
That's a big caveat.
I mean, that said, I just saw a gentleman's house that had burned down, a very nice couple whose house had burned down, and I don't think they were cutting any corners. They just had a product that was defectively manufactured, and it blew up in their garage.
Well, we'll get into that a little bit. Okay, so we're at the end of this segment already. Ken, will you give them some contact information for you?
Oh, sure, yeah. I mean, if anybody wants to find us, we're at www.piedmontinjurylaw.com. You can email me at ken@piedmontinjurylaw.com, or our phone number is 678-909-0770.
You're listening to Lewis on the Law. My name is James Lewis, and I'd like to let you guys know that not only is this show aired on Saturday mornings at 9 a.m. here on Biz 1190 AM, but we're also streaming nationally on every single major national streaming platform that you can possibly think of. iTunes, Spotify, and I think Google has some new branding these days. Who can keep up with it? But we are also AI compatible, so you can go to your AI device and say, Alexa, play Lewis on the Law, episode 56 with attorney Ken Crosson on, and this show will come streaming out of your AI listening device. How about that for modern technology? When we get back,
it just gets better and better.
I know it does. It's hard to keep up, but I actually love it. It's like it's kind of exciting these days. When we get back, we're going to take a look at the elements of negligence. You are listening to Lewis on the Law. My name is James Lewis, and like I said, I have another awesome show going for you guys today. I have attorney Ken Crosson on with me, and we are talking personal injury, and we're taking kind of a different path to it. We're taking a look at a couple of cases today that kind of highlight some important factors that you want to know in personal injury. Once again, I've got to throw this disclaimer out. This show is not meant to provide legal advice to you. This show is only designed to give you a little bit of information to help you maybe make an informed decision, understand if you have a case, understand maybe what types of attorneys you're looking for. Do not listen to this show and say, hey, I heard attorney Ken Crosson on Lewis on the Law, and now I'm ready to take on my own personal injury law case. If you have a serious legal issue, go ahead and contact the attorneys you hear on this show. I allow all of them to give out their personal information while on their show. If you have trouble remembering, just go ahead and give me a call and we can go through it together. Or if you have a real estate issue, you can always give me a call and I'll handle that for you. I actually get people who call me about these real estate issues on this show, which
Not
is
surprised at all. I'd call you about real estate issues if I had one.
Jeff, just remember that next time you have a dispute with your neighbor over your driveway easement, just keep me in mind.
Oh, yeah, that's great. That takes me back to law school.
Yeah, there you go. You know what? This doing a little research on your topic actually took me back to law school because, negligence. There's elements. There's like duty. There's breach. There's causation, and there's damages. So we were talking about this case, and we kind of got a little bit into duty. And I remember you said you had some. You knew some people whose house burned down.
Well, yeah, I don't want to share too much confidential information. I mean, it's an ongoing issue, but yeah, they're very nice people who I don't think were in the cutting corners boat, and these things still happen. So.
I cut corners all the time. One of my neighbors is a plumber, and I'm just like, hey, Jack, can you just come over here and help me out a little bit? And I don't think it's to code. But,
just make sure your insurance is paid up.
Yeah, shh. No one tell the housing inspector. Okay, so this case, Kerr Brothers versus Spahos, Spahos. I have this short A that I keep throwing in there. I blame it on that time I spent in California. But Kerr Brothers versus Spahos, the courts kind of go through the duty or the ordinary carry duty, and then the imminently dangerous duty or a vendee not to distribute something imminently dangerous to their vendee. Right,
I guess I don't know how much I can add to that. If you're selling something and you know that you should know that it's foreseeable that it can be imminently dangerous to the person you're selling it to. There are a whole bunch of duties that arise. There's the duty simply not to sell something that's unavoidably dangerous. There are duties to warn, and you have to include. I mean, you see it all the time when you purchase a product and an outcome. This list of do not eat. This piece of hardware you bought at the hardware store, and there's a little label in it that says, do not put this in your mouth and swallow it.
Or don't eat those little gel packets they put along with the clothing.
The silica gel.
Yeah,
don't eat that. I don't know why. Somebody must have eaten it at some point, and something bad must have happened.
Well, with those Tide Pods, I heard there's this thing where kids are thinking that that's candy because it looks like candy, and they'll pop one of them in their mouth.
My 14-year-old walked into the kitchen the other day and just looked at my wife and just deadpan, straight face said, "Mom, these new green laundry detergent pods, they don't taste as good as the other ones."
You know, when I was 14 years old, I might have actually tried that out to just see how that was.
Yeah, I don't think he meant it, but I'm not 100% sure.
Oh, so he's a boy, so he might have meant it. There you go. Guys have a propensity, and we're all guys here. So,
and you know that Tide is, I haven't seen a Tide package lately, but I'm sure that they're labeling it now. Do not eat, do not put this in your mouth.
Oh, no, they do. I've seen that. So it's pretty funny. It seems like you wouldn't have to warn people about that. But
but once it's all over YouTube, I guess it becomes foreseeable. I mean,
exactly.
Seriously, that's not, I'm sure that's something that a court would look at if a case like that went up. I don't know if one has.
So I think foreseeability was an issue in this case because the independent contractor, he basically put this furnace in there without any insulation, so that it was touching wood.
Right.
So,
there was the flue, which gets extremely hot, was not insulated and was running right up against a wooden header in the house. And any competent contractor dealing with that situation should be able to foresee that that's a fire hazard, that's a burn hazard. And of course, it was not compliant with the code. It wasn't properly inspected. So
yeah. So that's a big one, and that is foreseeable.
Was there a question of negligent design in the furnace in the first place?
I didn't see that in there, but I thought it was more geared towards the independent contractor's negligent actions or his actions in not getting the furnace put to code and not getting it inspected afterwards, just kind of placing it in there and then charging the homeowners.
Right, and then even if there had been negligent design in the furnace, if the independent contractor is in a superior position to recognize that defect in the manufacturing, he can still be part of that chain of liability for the product's liability. If someone wanted to sue the manufacturer for the defective product, the person who ultimately sold it to the consumer, knowing or being in a position where he should have known that it was foreseeably dangerous, could have that liability as well.
Exactly. So I think another item that this court looked at was just because he put the furnace in, and just because the furnace wasn't to code, and just because he didn't have it inspected, and just because the house burned down, they had to make a link of causation to the fact that it was that action which caused the house to burn down.
Well, that's part of the definition of a negligence claim. You know, you have to have the duty, you have to have the breach of the duty, and you have to have causation of an injury. It's not sufficient that somebody behaved irresponsibly or unreasonably, and incidentally some other thing happened. The breach of the duty has to actually be the cause of the duty. And you know, it's in some cases, like in this one, it sounds like it's obvious. You know, he ran the flue up against the header. The flue got hot, but it's possible. You know, the header could have gotten struck by lightning, right? I mean, there are other ways that the header could have caught on fire. And if a factual inquiry finds that, oh, it wasn't actually the breach of the duty that caused the injury, even though it certainly could have, then no, liability wouldn't arise. And that kind of makes sense, right?
Yeah, it does. But let's take a look at that. Okay, so say it wasn't the actual furnace that caused the fire, but say it was an electrical fire due to a short in the electrical system. But you still have an independent contractor who's cut corners, put this furnace in not to code, not had it inspected, and still charge the homeowner. Is there recourse there?
Well, now you're talking about whether there's maybe some kind of breach of contract.
Okay.
Where the person didn't perform in a commercially reasonable manner, and now the homeowner has a right to have the work redone. If the homeowner's inspected it and accepted the work, it's going to be a difficult claim to make. But if the homeowner has the work inspected and says, oh no, this isn't up to code, you need to redo it. But now we're not really talking about a personal injury case. We're talking about more just like a contract case.
A breach of contract case. Now that's interesting that you said that, because the independent contractor in this case made the argument that he did the work and the homeowner accepted it, and thus he should not be liable.
Well,
I mean that was interesting. I mean, it didn't hold up eventually, but.
Well, I mean, at the time that the homeowner inspected, the homeowner's not in a position to. The homeowner's not in the same position as the independent contractor. The independent contractor is expected to know his business and to know the requirements. I don't think it's very likely that unless the homeowner had hired an inspector and then had relied on the inspector's opinion, an expert opinion, that the homeowner is going to be held to have waived the obligations of the independent contractor when the homeowner can't be reasonably expected to understand what those are.
Now that's interesting, because then who does the duty lie on? I mean, is it the contractor who actually put in the furnace? Is it his duty to go ahead and get get it inspected, or is it the homeowner's duty? I mean, part of me, and this is the pre-law school of me. Now I love lawsuits, but the pre-law school of me would have been like, well, the homeowner should have taken some responsibility and gotten the stuff looked at. It's like, don't spill that hot coffee in your lap. You know it's hot.
And not necessarily in connection with this case. In this case, talking about the statutory or regulatory obligations on the independent contractor. But yeah, in all these cases where there's an injury, the person who's injured has a duty to what they say is mitigate damages, mitigation of damages. If you've been hurt by somebody else's negligence, you still have an obligation within reason to take steps to reduce the degree to which you were injured. So that would possibly be a viable counterargument. Hey, yeah, I did a bad job, but if you had behaved reasonably, the injury you sustained wouldn't have happened, or it wouldn't have been as severe, and therefore I shouldn't be held liable, or I shouldn't be held fully liable for your injury. And I could see that argument carrying some weight. And, a lot of times you'll see cases like this, and I'm sure you've seen it throughout your career, that you have fairly similar cases that go up, and in one case they make one set of arguments, in another case they make another set of arguments, and you could have really made both sets of arguments in both cases, but it just didn't happen that way. So I don't know if a mitigation of damages argument in this case would have carried some weight for the independent contractor, but I guess we'll never know until we see the next case.
Yeah, I have these 45-page pleadings where I bring every single action that I can possibly think of to make it fit into it. Anything that I possibly can, I'll just bring it and I'll plead in the alternative. We are at the end of this segment. So Ken, give our listeners some contact information for you again. Well,
you can find us on Facebook, or Piedmont Injury Law. I mentioned at the beginning of this show that we like to be involved in the community. We're doing all kinds of, I think, fairly unique things. I think we're a very unique law firm in the way that we approach our relationship.
We should talk about that a little bit.
Well, if you want to find out more about some of the fun stuff we're doing, if you go to 2019isthebestyearever.com, that website will take you to our events page, and that's going to show you a lot of the stuff we're doing, getting out in the community. We've put on some events for the community, some small events, some big events. We've got some big fundraising initiatives that we're working on. So you can find us there. You can find us Facebook. You can find us on Twitter at Piedmont Injury. And you can always find us at PiedmontInjuryLaw.com.
You're listening to Lewis on the Law. My name is James Lewis. And if you have a topic for this show, you can always give me a call at 404-610-0075. You can always go to my website, jameslewislegal.com. You can email me at james@jameslewislegal.com. And if you have a topic, go to my contact page, just drop me a line. And if I don't know the topic, I will bring an attorney on who actually knows something about your issue, and we will talk about it. All my old shows are archived on my website. You can go to jameslewislegal.com, and on my my vlog page, as I think Anthony was the one who told me it was properly called a vlog. I'm like, these kids these days, I just can't keep up with them. And then on my podcast page, all the radio broadcasts are collected there. When we get back, we're going to talk about mental pain and suffering. You are listening to Lewis on the Law. My name is James Lewis, and I am your host this week and every week. And once again, I got to throw out this disclaimer. This show is not meant to provide you with legal advice. If you have a very serious legal issue, go ahead and contract with an attorney. Do not use what you hear on this show to form the basis of your legal advice, to form the basis of your legal strategy or whatever you have. You need to go ahead and talk to a professional. All the attorneys that come on this show I allow them all to give out their contact information, so you can go through my archives. You can search for your issue and search for an attorney that may be able to help you with your issue. This show will also let you know if you actually have what's called an actionable issue, and maybe what type of attorney you're looking for, or what type of things do you need to go ahead and start to do to preserve your rights under the law. So, wait a minute. This show's streaming on, and I have this now, this nice little play, or this nice little script. This show is now streaming nationally. You can go to Apple Podcasts. We're streaming on Apple Podcasts, Google Play, Spotify, TuneIn, and you can go to your Google home device and say, hey, Google, play Lewis on the Law, episode 56 with attorney Ken Crosson, and this show will come streaming out of your AI listening device. You got to love modern technology.
It is amazing.
Yeah, and we were talking about that, and I'm actually really excited about modern technology. My first job out of law school was to help with a company that was building the information superhighway. So I mean, I was doing the site acquisition for them, but
of course, real estate, man.
Yeah, exactly. So. But I got really sold on the whole idea of that we will have this eventually interconnected America where there's not a single dead spot anywhere. The cities will talk to each other. Your house will talk to the trash man and tell them when he needs to come pick your
killing
trash.
Me, James.
Yeah,
killing me.
I know, completely AI living
Makes
within
me cringe.
within the furnace of your house, so that this furnace doesn't happen because it can say, things are getting too hot, and it'll wake you up in the middle of the night. Alexa will wake you up in the middle of the night and saying, Ken, the house is getting very hot. There's a problem here.
I can see some applications that I'd approve of if it keeps people from burning their houses down. Yes, but man, I think we're spied on enough. Alexa is not in my house. I don't want anyone. Although I'm sure my phone, everything I say, my phone is listening to everything I say, whether it's Alexa or not.
It's creeping up on you, whether you know it or not.
You see that you'll have a conversation, then you go and try to open your computer, and there are ads being pushed to you that are based on what you were just talking about with the person in the room with you. It's wow.
Yeah,
it's a bit too much for me, but you enjoy it if you enjoy it.
Yeah, it's creeping up on you whether you want it or not. It starts with your phone, and then it goes to your TV, and then next thing it's your watch, and next thing you know, you have AI living in the house with you. I know. You just want a house out in the woods with a log fireplace and a windmill and some water churning.
Yeah. An axe would be nice. I mean, I'd even go in for a chainsaw. My concession to modernity. But
well, we don't want the chainsaws to become alive and self-aware. That's a little scary.
No, we don't.
Yeah. Okay. So mental pain and suffering. I hear this everywhere. Every single client I get that has a suit, and I practice real estate law. So this is it's like my neighbor's dog pooped in my yard. Do I get mental pain and suffering?
Yes, and there aren't always clear answers in legal questions. I think there's a pretty clear answer in that one though. That no, you do not.
And I have to tell them, you know what? I can't just make up these things and put them into a court proceeding.
Right. You can try, but it's not going to do good things for your career. Judges see you bringing kind of frivolous claims like that. Pain and suffering, mental pain and suffering. It is a legitimate. In my world, pretty much every case that I handle involves, to some degree, mental pain and suffering. It's almost always a component of the damages. Clients. I mean, my clients, have typically all been through physically very traumatic events. And it's not at all infrequent for us to make referrals to psychological services, post-traumatic stress therapy and that sort of thing. So in my world, it's not the real estate world. Yeah, we see that a lot. But the elements for a negligent infliction of emotional distress claim, your dog pooping in your yard or just damage to your property in general is not sufficient. There has to be at least some impact to the individual. It doesn't necessarily, it's interesting because it doesn't have to be, it can be basically a purely emotional injury so long as there was at least, some kind of touching, some kind of impact. You have a car comes flying up at you and flipping around and at 100 miles an hour and it, just brushes your skin. That's a sufficient impact. But if it just flies past you and as a result, you're emotionally traumatized, you don't meet the threshold. So you have to be able to show some kind of a physical impact.
And that is interesting because here in the case that we're looking at here, Kerr Brothers versus Spahos or Spahos, depending on what part of the country you come from, the plaintiff is basically saying, I have injury to my purse, and shouldn't that be enough for me to get? Because I know when my purse hurts, that I go through a lot of pain and anguish. Trust me, when my purse starts, and I don't actually carry a purse, but we'll call it a wallet. Once my wallet reaches a certain level, I'm in anguish.
I think the court, very gently suggested that the plaintiff had kind of misunderstood what the standard was because now again, there's kind of two different flavors of infliction of emotional distress. There's negligent infliction of emotional distress, which doesn't contain the element of intentionality. And then there's intentional infliction of emotional distress. So negligent infliction of emotional distress does require at least some kind of impact, some kind of bodily impact with the person. There's an additional type involving witnessing the death of a child or something like that, but
that's beyond the scope
right.
of what we're doing here today.
But then intentional infliction of emotional distress, if someone acts with the intention of causing that emotional damage to you, and their conduct is outrageous, and they do in fact cause emotional damage, and it is severe, that's recoverable even in the absence of any kind of physical injury. And that could be accompanied by a financial injury. I'm sure that it very often is. Even if it's not necessarily a financial injury, you can have receipts for, but reputational damage, that's a big one. So defamation can very often carry an intentional infliction of emotional distress component because you've hurt the person emotionally, but through outrageous conduct and created a severe emotional distress. But unless it's intentional and it meets those criteria, there does have to be that physical impact.
And I think that's what the court was saying in this case, because here you had an action that's not intentional. I mean, it's just an independent contractor cutting corners. You might want to say that's intentional, but it's really not.
Well, the distinction there is that while pretty much always, your actions are intentional. You intended to do whatever it is you wanted to do, whatever it was you did, but the outcome that's being complained of here was not the intent of the subcontractor or the contractor. His intention was to save himself some time and aggravation and probably increase his profits on installing this furnace. His intention was not to cause emotional damage to the homeowner.
And that's the careful thing. And I think once again you hit the nail on the head when you said the courts said, okay, injury to the purse is not just injury to the purse, but it has to involve some physical injury also, and then injury to the purse.
Well, right. And when there's property damage only in a negligence case, there's basically no claim for emotional injury. There has to be that bodily injury. So someone could rear end your car while you're sitting in it. That's one thing. Rear end your car while you're standing next to it, and that's a different thing entirely if it doesn't hit you.
And I think that's where people get confused a lot with me, because most of my actions are just property actions, a lot of them. Some of them are just in rem, specifically in the thing itself. And people are always like, well, what about my emotional distress that I have gone through?
Unfortunately, in that context, you just have to suck it up.
Exactly. There's no hope for this. And I think these people had an issue. They watched their house burn down. They could have been in the house when it burned down. Luckily, they weren't. And so, people would naturally think that, yes, there might be some emotional distress, and maybe I should be able to recover for that.
Yeah, and I don't want to be glib because when somebody does suffer that kind of property damage and they're nearby, especially, there is emotional damage.
If my house burned down, I would be distraught. And
sure,
I would think that
you could have lost all kinds of sentimental, property with sentimental value, but the courts have to draw the line somewhere. Otherwise, every instance of hurt feelings, unintentionally committed hurt feelings that don't even necessarily rise to the level of severity.
All the time. I want to sue someone over it.
Exactly. It would not be good for society as a whole, and it wouldn't serve. It wouldn't help us advance the cause of justice if people were allowed to pursue those claims without reaching that threshold.
Yeah, exactly. Okay, so when we get back, we're going to take a look at Adair versus Baker Brothers, but I want to give you a little bit of moment here to go ahead and give them some contact information.
Yeah, sure. Well, you can always find us at www.piedmontinjurylaw.com. My email address is ken@piedmontinjurylaw.com, and our phone number is 678-909-0770.
You're listening to Lewis on the Law. My name is James Lewis, and I am your host this week and every week. And I want to let you guys know that all my shows are streaming on my website. You can go to jameslewislegal.com. If you have an idea for the show, you can go to my contact page. Go ahead and hit me on my contact page and let me know what type of issue you'd like to hear spoken about or talked about. And I'll bring an attorney on and we'll get into your issue. I know some of you guys have already reached out and I've brought on attorneys. Sometimes it takes me a little bit of time because I book about a month ahead of time to actually roll back around to your issue. So you guys just bear with me if you've already sent me emails. You can always email me at james@jameslewislegal.com, or you can give me a call at 404-610-0075. Once again, that's 404-610-0075. When we get back, we're going to talk about a husband who is electrocuted by a defective fan. You are listening to Lewis on the Law. My name is James Lewis, and I am your host this week and every week. And I have an awesome show going for you. I have attorney Ken Crosson on with me, and he is the managing partner at Piedmont Injury Law. And we are talking about personal injury today, but we're doing it by looking at a couple of very, very fascinating cases. Now, I know you guys out there, you guys think that we're giving you legal advice, but we're not. This show is only meant to give you information, to provide you with information. This show is meant to empower you, the listener. That's right. I love you, my brothers and sisters out there in Radio Land, and I want to empower you with legal information, but do not take this as legal advice. If you have a very serious legal issue, go ahead and contract with an attorney. Go ahead and hire an attorney. If you have an injury issue, a personal injury issue, if your house is burned down, go ahead and give Attorney Ken over here a call. If you have a real estate dispute, don't worry. You can call me. Go ahead, 404-610-0075. You can always email me at james@jameslewislegal.com, or you can hit me on my website in my contact page, jameslewislegal.com. Oddly enough, that's what most people do is they go to my contact page. I don't know why they don't just email me or call me. They go to my contact page and then they drop me a line there.
It must be a nice looking page.
I built it myself, so it can't be that great. I'm real cheap when it comes to these things. Just like, can I do it myself? Can I figure it out?
Well, I hope your website doesn't burn down then.
Along with my plumbing. Enough of that. Adair versus Baker Brothers. Okay, this is an interesting case because this is filed by a wife whose husband was electrocuted by a defective fan, and this brings into all kinds of issues, all kinds of things. First, there's something called strict liability. I don't know. Do you know anything about that?
I do happen to know a little bit about that.
It's a good thing I've got you here with me.
In the context of this case, it didn't really enter into the case. The plaintiff tried to bring that in, but the case was disposed of in favor of the defendant on completely other grounds. The court didn't really even look at the issue of strict liability. But strict liability, conceptually, it is liability that attaches when a bad thing happens. When a certain kind of bad thing happens, regardless of whether or not there was any negligence. So let's see.
So what kind of bad things? You're walking down the street and your neighbor's pet wolf pack leaps the fence and
that's a perfect example.
Rips your leg apart. Is that a bad thing? I mean, I think that's a bad thing.
That's great, but there would be a big difference between a pack of wolves leaping the fence and ripping your leg off and a pack of domestic dogs doing the same thing, because what the distinction there and what actually that's a great example because
you mean his terrier can't leap the fence and rip off my pinky?
He absolutely can, but we're not. We would be looking at negligence again and not looking at strict liability.
Okay.
Now, strict liability attaches in this context. We're talking about strict liability attaching to inherently dangerous activities. So, one of the archetypal ones is blasting. You're doing dynamite blasting. If you cause damage to somebody because you were blasting, it doesn't really matter whether you were blasting responsibly or blasting
negligently. It's
you just need you're responsible for it. If you keep wild animals, dangerous wild animals, like if you have a pet tiger, and people actually have pet tigers, but if you have a pet tiger, or there was a case in the news a few years ago of a lady who kept a chimpanzee.
I remember that, and it literally ripped another lady's face apart.
Chimpanzees, don't ever fight with a chimpanzee. They fight dirty, and they're way stronger than you.
Oh my God, I can't even imagine.
But keeping an animal like that, it doesn't matter whether you could have had it properly locked up and properly contained, and you did everything right from an objective perspective, but something bad ended up happening, you're still liable, and that's that domain of strict liability.
Okay, so that's interesting that the chimpanzee, because you wouldn't think of a chimpanzee as being a dangerous animal. I mean, people look at it
after
and they're
you've read that story, you would. Yeah,
I know. I can't imagine being attacked by an angry chimpanzee.
I have a friend of mine is a zoo veterinarian. She's the head veterinarian at a major metropolitan zoo, and she's described how chimpanzees fight. What they do, what they bite off first, and first they're going for the fingers, and then they go for the nose, and then they go for the genitals, and it's gruesome.
Oh my God!
Yeah, they don't just rip your throat out and let you die quickly. They take you apart piece at a time.
Oh God, that is horrible. That's horrible.
So if you own one of those, I guess you better have a really good insurance policy, or just don't own a chimpanzee. I think that's we were saying we don't give advice on the show. This is not legal advice, but I'm going to give you advice. Don't own a chimpanzee.
Nice. Now something that I've seen that is very and it looks kind of hip and cool is when a person has a wolf hybrid.
Yeah, and I honestly don't know what the legal status of a wolf hybrid is. Because is it a wolf? Is it a dog? When you're dealing with a dog, we actually have a couple of animal attack cases. We do handle that kind of case. The overwhelming majority of our cases, they're not this kind of interesting. They're all interesting in their own way, but the overwhelming majority of our cases are, car crash cases. Just you'd probably expect that, especially in the Atlanta area. But yeah, I don't know what the status of a wolf hybrid dog is. If you have a dog, there still has to be some kind of negligence on the part of the owner in order for liability to attach. It could be as simple as letting the dog off a leash and then the dog bites somebody. But again, that negligence has to cause the injury. And I think a purebred wolf would probably fall into that dangerous animal category and strict liability.
I would think that would be a dangerous animal. I'm a little bit worried about the wolf hybrids myself. Okay, so back to our case here. So strict liability didn't come into play. How about negligence? Does it come into play in something like this where there's a defective, maybe there's a defective item sold?
Oh, absolutely. And this kind of echoes the issues we were talking about previously, where dangerous manufacture. You've produced a dangerous product, and you either know that it's dangerous as you're selling it to somebody, or you should have known that it's dangerous. It's what we call imputed knowledge or constructive knowledge. Yes, so the strict liability might have come in. We don't really know because the court doesn't really get an opportunity in this case to discuss the merits of that because they didn't need to. They resolved this case because the statute of limitations had passed, and they resolved it in favor of the defense. But yeah, negligence in product manufacture it's basically the standard in all of these personal injury type cases. Negligence is what we're looking at, unless it's either negligence or it's gross negligence or it's something else, like when you're talking about punitive damages or you're talking about, in this case, strict liability.
Got it. So, this kind of, I want to kind of go back to something you said a little while ago, and it was kind of brought up in this case, but they were the implied warranties. And I think when you get an item, and like you said, this case was actually decided on the statute of limitations and not on these issues, but still, doesn't a person have some sort of right to make sure that the electric fan that's sold to them by a vendor works for its purpose and doesn't electrocute them?
Exactly. And the implied warranties we're talking about are the implied warranty of merchantability and the implied warranty of fitness for a particular purpose. And the idea is, even if nobody ever says anything about this, the purchaser, the consumer, should be able to assume that the product that's being sold for a particular purpose is fit for that purpose. A product that's being sold to a consumer is not foreseeably and unreasonably and imminently dangerous. Now, obviously, you have products that by their very nature are dangerous, like we talked about chainsaws earlier, and meat slicers and power tools and all that. Right, those are dangerous even when they're operating correctly. What we're talking about here is where there's negligent manufacture, and as a result, something is dangerous in a way that would not be foreseeable to the consumer because they have a right to expect that it's not going to pose that kind of a danger to them when they buy it. But that would be foreseeable or should have been foreseeable to the person who sold it to them, or the person who manufactured it, the person who distributed it, etc.
So when you're talking implied warranty of merchantability and implied warranty of fitness, are they the same thing or are they two different things?
Well, fitness for a particular purpose, merchantability is kind of more general. Merchantability literally means this is something that is suitable for sale.
Okay.
Regardless of what it's going to be used for, what it's going to do. Then there's if someone sells you a fan and the fan isn't dangerous, it just doesn't work. It doesn't move air. That would be it's unfit for a particular purpose. And so even if the person had not said, I warrant to you that this fan that I'm selling to you is going to move air, it's implied that the fan's going to move air. And if it doesn't move air, then the seller, just typically, what would happen with you or me is you buy a fan and it doesn't work, you take it back to the store and they give you a refund. And it's probably outside of our experience that you'd ever have to consider going to court to deal with something like that. But, in other contexts, that's really what they're looking at is, was it fit for the purpose that the seller knew the purchaser intended to use it for.
Mm-hmm. And I would want this case to, and we're not going to get to the exciting, dramatic conclusion of this case because we are out of time. But
bodily injury statute of limitations 2 years, property damage generally 4 years. So that's what happened here. She sued too late.
Yeah, she sued too late. So make sure you once this happens, bring the action. Don't sit around and sit on it because then this turns into a wah-wah. She might have had a case, but anyways, we're at the end of our show. It was a great show. Thanks for coming on with me, Ken. Can you give our listeners some contact information for you once again?
Yeah, absolutely. We're Piedmont Injury Law. You can find us at PiedmontInjuryLaw.com. You can find us on Facebook at Piedmont Injury Law. You can find us at 678-909-0770. And if you're interested in any of the community outreach and the activities that we're doing up in the community, you can find out all about that at 2019isthebestyearever.com.
The best year ever. Does that mean we're going to make the most money this year?
It's all across the board.
It's all across the year.
Simply the best year ever. We decided at the end of 2018 that 2019 was the best year ever. We declared it from the outset, and we've just been working to make it that way all through the year.
Excellent. You heard it here straight from Attorney Ken that 2019 will be the best year ever.
No. It is the best year ever.
Okay. It not it will be. It is the best year ever.
It's not a prediction. It's a declaration.
Got to get it right. You're listening to Lewis on the Law. I love you guys. We'll see you next week.